Well, I am Mwese Modukbe Mnim. On this episode, we are going to be looking at sources of Nigerian law. Where does the law come from? At the end of this episode, there are outcomes that we are hoping that we are going to achieve by virtue of this episode. And that is one, that you'll be able to identify and explain the sources of Nigerian law. Two, you also understand the hierarchy among these sources. The third thing is that you'll be able to apply the correct source in solving legal problems. And finally, you'll be able to appreciate Nigeria's plural legal system. By the way, if you are not a member of our community, what exactly are you waiting for? Kindly join our community by clicking on the subscribe button, and you automatically be subscribed as a member of our community. And this teaching proves helpful to you in one way or the other. Kindly don't keep it to yourself, share it with others, and give us a like by way of clicking on the like button. And you need to say something to us, kindly do so by meeting us in the comment section. Now, I was asking, where does the law come from? The sources of law are actually the origins from which legal rules derive their authority as well as derive their legitimacy. So a proper understanding of the sources of Nigerian law is the foundation and is indispensable, because legal arguments, legal decisions, and academic analysis must always be grounded in a recognized source of law. When you are making an argument in law and is not grounded or founded upon a recognized source of law, what you are saying actually does not have an under to its standing. And in law, you cannot put something on top of nothing and expect that something to stand. And so, since it cannot stand, it must, as of a necessity, crumble. And that's why you must know the origins of the law in order to ground your legal argument within a recognized source of the law. So in this episode, we will examine the principal and subsidiary sources of Nigerian law, their hierarchy, the scope of application, as well as the practical significance of each. Now, what is the meaning of sources of law? Anytime you hear the term sources of law, this refers to the origins or authoritative basis from which legal rules are derived and upon which courts rely in cases of adjudication. So sources of law answer two fundamental questions. The first question that sources of law answer is, what rules qualify as law? And the second question they answer is, why are such rules binding? Now, in Nigeria, for instance, the legal system is pluralistic, drawing from constitutional, statutory, judicial, customary, Islamic, and received English law. So, we will first begin by looking at the Constitution as the primary source of Nigerian law. And by so doing, we are going to be examining the supremacy of the Constitution. The Constitution of the Federal Republic of Nigeria, 1999 as amended, is the supreme law of the land. This in legal terms is described as the ground norm. The ground norm is the foundational or the highest norm, is the norm that gives other norms their validity. In other words, every other norm derives its validity from the ground norm. So section 1 sub 1 of the Constitution provides that the Constitution is supreme, and section 1 sub 3 declares that any law inconsistent with the provision of the Constitution is null and void to the extent of such an inconsistency. Now, this establishes the Constitution as the highest source of law in Nigeria. It also establishes the Constitution as the foundation of all government authority. And finally, it establishes the Constitution as the benchmark for validity of all other laws within Nigeria. So we will look now at content and scope thereof. The Constitution provides for structure and powers of government, for fundamental human rights, for legislative competence, which includes exclusive, concurrent, as well as the residual list. Then it also provides for judicial powers and court hierarchy. Now, every legal inquiry in Nigeria must ultimately be consistent with constitutional provision. And where this is not so, we've already said same will be null and void to the extent of such an inconsistency. We'll now be looking at another source, which is legislation, otherwise known as statute or statute law. What is meant by legislation? Legislation refers to laws that are enacted by competent legislative authority. By this we mean that any authority that is empowered so to make such a law, when it does make such a law, that kind of law is a legislation. So in Nigeria, legislative power is vested in the National Assembly for federal laws, and the National Assembly, of course, consists of the House of Reps or House of Representatives, as well as the Senate. So then it also comprises of the state houses of assembly of all the states. And then, of course, there are some laws that are normally made at the local government level by the local government councils. So we will now look at types of legislation, and by so doing we'll be looking at primary legislation as well as subsidiary or delegated legislation. Now, primary legislation are the acts of the National Assembly and laws of state assemblies. These are primary legislation. On the other hand, are subsidiary or delegated legislation. These are rules, regulations, orders, and bylaws made under statutory authority. By this is meant that probably a statute or a law empowers an organization or a body to make certain law. So when that body makes that law, which body is other than the houses of assembly or the legislative houses, such a law is going to be known as delegated legislation. Why is it delegated legislation? It's because it's not the primary duty of such a body to make law, but a certain statute or act or law has delegated or donated to them the power so to do. And when a body is delegated a power to make legislation, that body cannot further delegate that power to another body to make that law. Why is that so? It's on the legal maxim that delegated powers cannot be delegated. So we'll now look at the importance of legislation. Now, legislation is important in that it is the most direct expression of the will of the state. Secondly, it provides for certainty and uniformity of laws, and then it can override common law as well as customary law. And finally, is subject only to constitutional validity. So in modern Nigeria, legislation is the most prolific source of law, actually. We will now look at another source, which is judicial precedent or case law. What do we mean by judicial precedent or case law? Judicial precedent refers to law that is developed through decisions of courts. So when cases come before courts and courts make pronouncement on those cases, the judgments they make form what is called case law. So case law are actually laws that are made from what? From cases. I think that's the simplest way to define what case law is. So now, how case law operates is that it operates and gets its force from the doctrine of stare decisis. Now, the doctrine of stare decisis is to the effect that the courts are bound to follow their previous decisions in similar cases, especially when those decisions were made by courts uh, of superior standing in relation to the hierarchy of courts. So we will look at what ratio decidendi and obiter dicta are, because this works hand in hand with the principle of stare decisis. So ratio decidendi is the legal principle on which a case is decided now, and that's what makes it binding. So, and the other is obiter dictum. So obiter dictum are made in passing, they are persuasive, but they are not binding, because they are statements that are just made in passing in relation to the matter in issue. So they may have a persuasive authority, but they are most certainly not binding. We'll now look at hierarchy and binding force. So there is a relationship between the hierarchy of courts and whether their decisions are going to have a binding force, or the weight of the bindingness of their decision. So the decisions of the Supreme Court bind all lower courts. All lower courts are bound by the Supreme Court. Okay. So the Court of Appeal binds high courts as well as lower courts. Then high courts bind subordinate courts within their own jurisdiction. So judicial precedent ensures certainty, predictability, and consistency in law. Because when the law is not predictable, is not consistent, and is not certain, then the law is bad law. Another source we'll be looking at is the received English law. Now, what do we mean by received English law? Received English law is what it is the English law that was received in Nigeria. So English law forms part of Nigerian law by historical reception during that colonial period. When Nigeria was colonized by England, English law was brought into the nation. That's what is meant by received English law. And received English law consists of common law, consists of the doctrines of equity, as well as the statutes of general application enforced in England by 1st January 1900. These statutes of general application are usually called SOGA for short. So now we'll look at the scope and the limitations of English law, the received English law. The received English law applies only where Nigerian legislation is absent. It also applies where it is not inconsistent with Nigerian law. And finally, it applies subject to local circumstances and conditions. So English law is therefore subsidiary and residual in nature in Nigeria, because right now Nigeria is no longer tied to the apron strings of imperial England. We will now all look at customary law as a source of law in Nigeria. What do we mean by customary law? Customary law consists of the indigenous norms and practices amongst the various ethnic groups within Nigeria that are recognized as binding by local communities and enforced also by the court. So Nigeria has diverse customary laws because the ethnicities in Nigeria are equally diverse. We look at how customary law may be accepted in the regular courts, and this particularly is by the use of validity test. So customary law is enforced by courts only if it is not repugnant to natural justice, equity and good conscience. It is not also incompatible with any law that is enforced, and finally it is not contrary to public opinion. What is the scope of application of customary law? It applies mainly in things like marriage, family relations, succession and land tenure. We will now look at Islamic law. Islamic law is recognized as a source of Nigerian law, particularly in northern Nigeria, but it's operational all over the federation, but is more popularly attached to northern Nigeria, perhaps because Sharia law is in operation in the northern part of Nigeria with Sharia courts and all of that. So it applies to personal law matters, marriage, divorce, inheritance. Now, certain criminal matters in states that have adopted Sharia legislation may also apply. So Islamic law is administered through Sharia court subject to constitutional safeguards. Now, another source of law is international law, and you find this in treaties as well as in conventions. So international law does not automatically apply in Nigeria, of course, unless it is domesticated. When it is domesticated, it will become applicable in Nigeria. So undomesticated treaties may still have persuasive value, particularly in human rights adjudication. We will now look at the hierarchy of sources of Nigerian law, and the first on this hierarchy is the Constitution, followed by legislation, followed by judicial precedent, followed by customary law and Islamic law, followed by received English law, and finally international law when domesticated. This hierarchy determines the validity and priority in cases of conflict. Why is it important that you understand the sources of law? It's important that you understand the sources of Nigerian law because it will enable you, whether as a student or as a practitioner, to identify valid legal rules to serve your specific purpose. And it will also help to resolve conflicts between laws, because sometimes conflict usually occur between laws, especially where there is a plurality of laws. Conflict of laws may occur. Then it also helps in constructing sound legal arguments, and finally it helps to avoid reliance on invalid or inferior authorities when you could have relied on superior ones that have a higher level of bindingness. So a lawyer's credibility depends significantly on correct citation and prioritization of legal sources. So it's important that you should know these legal sources. By way of conclusion, Nigeria's legal system is characterized by pluralism as well as hierarchy. And while the constitution reigns supreme on this hierarchy, other sources operate within defined limits. Judicial precedent, legislation, customary law, Islamic law and received English law collectively shape what we know as Nigerian jurisprudence. So it's important that you have a sound grasp of these sources of Nigerian law as foundation or foundational to your legal reasoning, advocacy and judicial decision making. I hope you did really enjoy this lecture and you were able to take away something from this lecture. If you did, let me ask you, to what extent does English law still influence Nigerian law? Or do you think that English law no longer influences Nigerian law in any way? I would like to listen to your comment. I would like to see your comment in the comment section. Till next time.